Yes, Mr. Tanner.
May it please the court. What I'll do in my remaining time is look at the judgment below and then make concise submissions. The judgment below you will find in the core bundle at tab 9. You go in it please to paragraph 23 at the foot of page 5. This is where we pick up the thread. It's the heading of the issues just above paragraph 22. Paragraph 23, the judge records that it's common ground that there has been deliberate concealment. So the disputed question is when time starts to run. Turn the page, go to paragraph 24 at the top. Judge reasons correctly that this turns on the date on which Gemalto discovered or could have discovered the essential ingredients of the cause of action. She then lists out what these essential ingredients are in a case such as this, in both paragraphs 24 and 25. And you'll see that in paragraph 25, the end, she refers to the fact that the time period covered by the cartel agreement has to be known and pleaded, although there was a dispute as to how precise you have to be. Paragraph 28, she crystallises the key issues in the case at letters 1 to 3. The first, letter 1, corresponds to the issue that is now ground 1 in this appeal, whether Gemalto's knowledge could in principle be established on the basis of the announcement of the investigation and adoption of the SO, together with the press reports concerning the investigation and the RFIs.
I mean, we have read it pretty carefully, Mr. Tanner.
The second, ground 2, corresponds to the issue which is ground 2 in the appeal. The third concerns the relevance of the belief of Gemalto's witnesses as the existence of the cartel. And although the judge treats that separately, you will have heard from my submissions that this was in truth an aspect of the first issue. And the reason I say that is because the belief of Gemalto's senior businessmen about the existence of a cartel is not merely a subjective matter which is irrelevant to the question the court has to decide. It casts light on the perspective of a reasonable person.
Do you say she was wrong about that? I mean, because that's not a ground of appeal.
Wrong about?
About her approach to the witness evidence.
What we say is it's a factor that feeds into our first ground as to what was available to the victim here at the time of the SO, because she should have appreciated that one of the factors was that the business people at Gemalto had been told, as our skeleton points out, that they've done exhaustive internal investigations which have revealed no suspicious facts. She only deals with the question of what the witnesses knew and said at the end of her judgment, and she doesn't address it as going to the question of discovery under the first ground, and that is how we say it arises. Now, on page 7 of her judgment, paragraph 30 and following, the judge summarises there the material which was available to Gemalto. And as I say, the account she gives here at what the recipient has, the target, is incomplete because she leaves out the statements made to Gemalto by Infineon, both directly and via announcements. So she does record, you see in paragraph 32, that 2 of the officials were asked by their superior to fish for serious information when the news broke of the investigation. She doesn't complete the point by recording what actually came of that fishing, which was Infineon's assurances that the investigation into it, at any rate, were misguided. And those, as I say, are the components of what amounts to whether they achieve discovery at the relevant time. The judge turns to address the meaning of discovery from paragraph 40 in this judgment on page 9. And you'll see there, under the heading, the meaning of discovery, that what she does is she refers straight away to the Supreme Court's judgment in FII on page 10, at paragraphs 46 and 47 at the top. She refers there to the question of sufficient confidence, And she does it mainly in order to point out that in FII the Supreme Court departed from the customary statement of claim test as marking the point of discovery. And she refers to what the court said there about knowing about the mistake with sufficient confidence to justify embarking on the preliminaries to the issue of proceedings. Embarking on the preliminaries to the issue of proceedings, and I come back again to what it is that one is investigating. It is doing that process, embarking on the preliminaries, actually issuing the claim. The key question for today's purposes, as we know, is when the claimant can be said to have this sufficient confidence to apprehend that there is a worthwhile claim. In paragraph 51 of her judgment, foot of page 10, the judge states in the first sentence that the claimant must have sufficient material to be able properly to plead the relevant facts because she's relying on Granville. And over the page, at the top of page 11, she records, and here she's picking up on FII, that the standard is one of reasonable belief of the facts giving rise to the relevant cause of action. So to that extent, she does incorporate the teaching of FII. Then the important discussion and analysis section of her judgment begins on page 12, from paragraph 59. And at paragraph 59, the judge records that the SO is the preliminary position of the Commission after an in-depth investigation, and she engages in the process of reasoning that I outlined at the outset of submissions. It's not merely speculation or suspicion, it's founded on evidence that has been gathered. At paragraph 62, she makes a comparative point, saying that the Commission's evidence base will be far fuller than is normally available to a claimant bringing a standalone claim. And finally, paragraph 63 is the meat. She concludes the damages claimant's entitled to form a reasonable belief in the existence of the cartel described in the SO. Reasonable belief in the existence of the cartel. More accurately, that's the existence of the cartel described in the Commission's press release, in circumstances where the Commission has reached a preliminary view about it. Paragraphs 64 to 67, the judge addressed what was a submission from me that the inference of cartel wrongdoing can't legitimately be drawn from the fact that the Commission has shown it considers that there is a case to answer and therefore that there is a possible infringement to be unearthed. And that remains our position. We say it's a straightforward point. Paragraph 64, you have the judge's response. And it's worth dwelling on what she says. It's that at the stage of bringing a cartel damages case, the facts are largely within the exclusive knowledge of the defendants, and it's established the courts will take a generous approach to the sufficiency of the pleading. So in other words, the judge is suggesting that the measure of generosity accorded to parties who plead cartel damages cases doesn't only go to the question of how the cartel was organised and the precise time frame and such like, and the particularity with which you plead all of that. It extends to the prior question of whether there was actually a cartel in the first place, whether that essential ingredient of the cause of action exists. And I'll address that shortly. Over the page on page 14, the judge addresses at paragraphs 68 and 69 what are two separate points in a compressed manner. So I need you to be aware that there are two there. The first is the submission based on judicial policy. And our submission was that if time does start to run against claimants in the follow-on damages case like this, even before the infringement decision from which it follows on, it's inevitable, as we were discussing prior to lunch, that there will need to be a stay until the Commission's decision is reached. And when the Commission's decision is reached, the findings could be narrower than the press release announcing the SO, or there might not be an infringement decision. So a decision that the announcement of an SO gives you sufficient confidence in the fact of the underlying infringement to mean that time starts to run will, as a matter of judicial policy, serve no useful purpose, and it will be apt to lead to the filing of speculative claims which subsequently need to be withdrawn or amended. And the judge's reasoning in response to that submission you see in paragraph 69. And her reasoning was that, in effect, a claimant may prefer, as a matter of their litigation strategy, to await the final decision before embarking on a claim, and often there will be some time left in a 6-year limitation period to do it. So, for example, if you have a 3-year gap between an SO and then the decision, that still leaves you, on this logic, with 3 years to do your investigation of everything that needs to be investigated by way of preliminaries before you issue the case, and then proceed to issue the claim. In the last sentence of paragraph 69, she holds that where that sort of strategy isn't possible, because the Commission's investigation looks like it's more protracted, well, then the claimant can issue a damages claim on the strength of the announcement of the SO and seek a stay. I said there were 2 points. The second point addressed in paragraph 68 was a different submission. And this was the contention that the claimants in cases about secret cartels ought to have a solid foundation in the evidence before proceeding to bring a claim. And this is the analogy with fraud cases. I was not making a submission that secret cartel cases are fraud cases. This is a submission that they share relevant characteristics of unconscionable behaviour, and as in this case, conscious deception of customers, so that it's appropriate for the evidence which is available to the pleader to be such as to tip the balance from innocence to guilt. And the judge dealt with that submission in paragraph 68 by holding that the fact the Commission's issued an SO does provide a solid enough evidential foundation for a damages claimant to infer wrongdoing. You see that from the sentence starting in the present case, about 8 lines down. In the present case, however, a claim following the announcement of the SO would not have been a speculative claim with no solid evidential foundation. And the last piece of her reasoning in support of the decision is in paragraphs 70 to 78 of the judgment, where, to summarise, she said that the prior decisions of Nokia and Granville supported her analysis. So that's it. Those are the main elements of the judge's reasoning on ground 1. She addressed the point in our ground 2 in paragraphs 80 to 85, which starts on page 16 of the judgment. There, in response to the submission, there was nothing in the Commission's announcement of the SO at all about the time period of the cartel. She reasoned it was legitimate to infer the cartel period for pleading, or to assume there's a worthwhile claim, from the ambit of the information requests which had been sent the previous year. And she makes 2 particular points in paragraphs 84 and 85. Point 1 in 84 is that a requirement for a precise pleading on the cartel period would put an impossible burden on the standalone claimant. And in paragraph 85, she said that although the pleader would have to draw an inference from the fact that there'd been these factual information requests, it's likely to be inevitable to draw inferences from available material in most standalone cartel cases. So that's the map. Those were the points in her reasoning which I shall now address. Begin with ground 1. First point is that the judge took a fatal misstep in her reasoning that the issue of a statement of objection, in combination with the other bits and pieces about the Commission's investigation that she refers to in paragraph 28.1 of her judgment, enables a claimant to appreciate that the essential elements of the cause of action are present, and therefore, because that's the basis for saying this, that a worthwhile claim arises, and therefore that one may go off to embark on the preliminaries to the issue of the writ of the claim. And that's, we say, the correct sequence. My essential submission is that the announcement of the SO tells the claimant only that there is the possibility that the essential elements of the cause of action do exist, which still remains to be established. It does not show at that point that there is, in the language of the Supreme Court, a worthwhile claim. Now, in their appeal cases, both the respondents adduce an array of material which is meant to support the proposition that the fact of issue of a statement of objections does permit the inference of wrongdoing determined by the judge. And my case is that none of it does do that. It's appropriate to recall the key points which the European Court has consistently made about what are the nature, the function and the purpose of this statement of objections. If I may, I'll take you to only a limited number of authorities. First, if you would turn up, please, authorities at tab 55 and go in it to page 4.
Sorry, just left me a bit behind. What are we looking at here?
So what I'm going
not
to...
what case, but what are these cases for?
I'm sorry. So this is about the significance of the statement of objections, which we've so far talked about, but not looked at in terms of what the court and the commission say it means.
Okay, and you want to go to tab 55?
I want to go to tab 55, please. Tab 55 is the textbook that which was referred to by Renesis and which we've referred to in the supplemental skeleton as well. If you go in it to page 4, you have the heading, nature of the statement of objections.
Sorry, I haven't got tabs in here.
I'm sorry.
Page 144. 1441. Thank you.
Apologise for that. So the nature of the statement of objections is the heading.
Yeah. And which is this textbook?
This is called Kurz and Kahn, who are two senior commission officials, the legal service. Mm-hmm. And in the first indented quotation there, you see the authors recording the Court of Justice's very succinct description of the nature and purpose of the statement of objections. A procedural and preparatory document intended solely for the undertakings against which the procedure is initiated with a view to enabling them to exercise effectively their right to a fair hearing. And I apologise, the case that this quotation comes from...
I'm sorry, I can't see which paragraph in the textbook.
So it's 4/011, and you'll see it begins under the heading nature of the statement of objections, although the SO is well established as an indispensable feature. I don't know if your Lordship has that. And you'll see an indented quotation which is taken from a Court of Justice case, describing that it's a procedural and preparatory document intended solely for the undertakings to enable them effectively to exercise their right to a fair hearing. The case it comes from, I'm afraid it hasn't got into the bundle, but the footnote takes you there, is BAT and Commission, joined cases 142 and 156 of 84. I believe that's referred to in our supplemental skeleton. Second point, it follows from what this is, from the nature of the statement of objections, that the Commission must be prepared to amend or abandon its position in the light of what the addressees tell it in response. And if we go please to tab 35 of the authorities, this is another of these classic cartel cases. It's called Aalborg Portland, decision of 2004. We go please to page 5.
Do we have any figures? Did the judge have any figures on how many statements of objections result in decisions?
My Lord, no. My own research has found that's actually quite difficult to ascertain. Not least because it's
You've
not
been practicing in this area, Mr. Turner, for very many years. You could.
for a little time.
Yes.
But the
well, I'm not meaning to be rude about the number of years, but I mean it's quite a high percentage, isn't it?
It's also a high percentage of cases where the Commission amends the findings, withdraws some allegations, narrows them, some parties drop out.
Probably all of them, yeah.
Well,
You change them in some way.
yes,
Yeah.
or narrows it in a way that may be relevant to a damages claim.
Yes.
So if we go, please, to the consequential point, Authorities 35, this is Albul Portland, there we are, it's on screen now. Paragraph 67. This describes what you have to do in the statement of objections, set clearly all the essential facts on which the Commission is relying at that stage of the procedure. It's not necessarily required to be a replica of the decision of the statement of objections. Since the SO is a preparatory document containing assessments of fact and law purely provisional in nature, for that reason the Commission may, and even must, take into account the factors emerging from the administrative procedure in order inter alia to abandon such objections as have been shown to be unfounded. So that's the rule, and the third and final step is that this in turn entails that the statement of objections is, as my lord you say, liable to change, so that no assumptions can be made about the likelihood that the allegations advanced are correct. We go please to tab 40 of the authorities. This is the very recent case of Qualcomm, decided in April 2019 by the General Court. If you go in it please to page 8, you see at paragraph 65 towards the bottom, if we can magnify that the applicants there were arguing that the Commission shouldn't be allowed to expand their investigation, keep looking at things after the issue of the statement of objection. They said it was legitimate to expect that after 7 years of investigation in that case, the fact-finding was complete. If you turn the page to the following, page 9, you'll see redlined paragraph 70 and 71, and you will see there both the statement that the Commission has to take into account points that are made that show that it's got things wrong, and therefore making the point that this document is inherently liable to change, subject to change. So those are the essential points from the Court of Justice's description. In the Commission's public documents 2, the Commission emphasises that the allegations in the statement of objections may well lead to the closure of the case without the adoption of a decision. And on that, if we please go to tab 53 in the authorities, this is the Commission's so-called best practice note. In tab 53, if we can go to page 15, just expand that, we're looking at paragraph 77, which is redlined. So the Commission itself describes it as follows: an important procedural steps in procedures which may lead to a prohibition decision is the adoption of an SO. However, the adoption of an SO does not prejudge the final outcome of the investigation. It may well lead to the closing of the case without the adoption of a prohibition decision or a commitments decision. So that's a bird's eye view. Infineon argues in its skeleton argument that the issuing of an SO amounts to a formal accusation of wrongdoing akin to a person being charged. You see that from their skeleton, paragraph 51. I don't need to go there. And we can accept that categorization. But it doesn't provide a reasonable belief that the formal accusation is well founded, and nor would the Commission ever say that. I described earlier the fact
Does it, I mean, the question is not perhaps that, but does it provide a foundation for the conducting of investigations or preliminaries?
well,
Depends what is it that's expected to be triggered.
it what it does is first
Or
of
might
all,
say there's a smell. The
Yes.
SO creates a stink, but no more. With
yes,
the windows open, it might evaporate. It might get worse. But the question is that enough to trigger the investigation or the preliminaries, whatever they mean, and however they might be manifest?
my lord, you're right. My analysis is as follows: when you know that an SO has been issued, you know that you've come to a fork in the road, that the Commission may go forward and it may make relevant findings which show that the essential elements of the cause of action are present, or it may not. It does show that the Commission is investigating that point. But my submission is that investigating at that point is different from the investigation meant by the Supreme Court in FII, because what they were referring to is the investigations that take place when you have established that there's a worthwhile claim, because you know that the essential elements of the claim exist. And it's those investigations which constitute embarking on the preliminaries to the issue of the writ. And in a case such as this, as your lordship knows, there's a lot of work that then needs to be done once you have the essential foundation laid to decide whether and how to plead a claim. Those are the investigations which are meant. Otherwise, what one has is merely a proposition that time starts to run against the claimant in Section 32 cases when there is the possibility that the essential ingredients of the claim will be found. And that cannot be right.
In that context, can you just help me with what is meant in paragraph 195 of FII, where they refer to with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, which is the point you just made, but then such as submitting the claim to the proposed defendant, which seems to beg the same question. What do they mean by submitting a claim to the proposed defendant? That rather presupposes you've done your preliminaries. Does it mean just the letter before action? Or?
Well, my lord, to be honest, that was one of the same thoughts that I had too. I do imagine that this is referring to the point where you have done all your homework internally, you consulted your lawyers, you put together something, and then you submit the pro forma of the claim, or the inchoate claim as a letter of action to the other side to see what their response to it is. So it comes at that later point.
But remember, they're talking about knowing stuff that is substantive to the claim, whereas we're talking about there having been unconcealing what was previously concealed. It's different.
Yes, though in this case, this is unconcealing that there was the collusive agreement.
Yes,
which
but you
means
you can't have it that you've got to unconceal it to the point where you're absolutely sure it happened.
That's right, and in relation to that, we do not set ourselves the standard of absolute certainty, which in this sort of case would come from a European court decision or anything of that kind. What we do say is that the statement of objections is not giving you what one may describe as a reasonable belief, or one may describe as an appreciation that at that point you have a worthwhile claim because you know that the essential elements of your cause of action are present. You only know that there's that possibility still to be determined. So finally, it's worth taking a step back to clarify why the Commission might well find, in a case like this, that the initial allegations are wrong. In this field, as the members of the court will know, it's not merely smoking gun documents which emanate from the wrongdoers that plainly show there was a conspiracy, unlawful cartel. The Commission often has suggestive documents, and it typically builds a case from inferences and from observations about apparent distortions in the structure of the market and so forth. And it can make mistakes in the absence of having a full understanding of how the market works. And that is why we've referred in this connection to the soda ash cartel case, which is at Authorities 32. This is one of the well-known examples where this occurred. Authorities 32, please. Go to page 3. Go to page 3. You had at the bottom paragraph 76. That should say 76. And then we'll see over the page in a moment paragraph 77. These drive home this important point. So that's 75, 76. Yes, on the count of the weakness in that particular case of the documentary evidence, the Commission should, in order to demonstrate to the requisite legal standard the concerted practice alleged, have essentially gone into a more thorough economic assessment of the relevant market to understand what was going on. If you go over the page to 77, a little bit further down to Caesar of 77. Again there, the companies were saying, as they often do, you're misinterpreting what you see from this evidence because there actually wasn't unlawful collusion. Once you understand the way in which this market works, you'll see that it was a perfectly innocent, ordinary business practice. And it's in relation to that that the court points out that the Commission has to do its homework properly. And this is the sort of thing that can lead the Commission, after it has issued an SO, but then heard the parties, to decide that it needs to either narrow or abandon the original allegations. Now, my second submission was going to concern the judge's reliance on the judgment of Mr. Justice Sales, as he then was in Nokia, and Mr. Justice Foxton in Granville. But your Lordship has given me a steer that I shouldn't go into that in detail, and I shall not do so. I'll merely make my essential points about it and then wait to hear from the others. The points are these. The facts of Nokia were very different from ours. You had there a body of independent material about the suppliers who were implicated in a worldwide conspiracy on which the claimant drew. We don't know the full extent of it. You do know from the judgment that none of the defendants took a point that it was insufficient to give rise to a reasonable belief in wrongdoing or anything of that kind. And it's therefore not the case that the Commission's press release announcing an SO in that case, or any other unstated information about the Commission's investigation, constituted the evidential basis thought sufficient to justify the claim. And nor indeed is that what Mr. Justice Sales said. What he said was that it was particularly in the light of the Commission investigation that Nokia drew up the particulars of claim and issued the claim form. In other words, the fact of the Commission's investigation was the occasion for Nokia to bring the litigation, but he was not saying that the repository of information relied on by the claimants was taken from the announcement of the SO in that case. It clearly wasn't. And more importantly still, the issue before the court today was not an issue either raised or considered in that case, as my lord you've said. And that is why Nokia doesn't represent support for the judge's reasoning that a claimant can rely on the announcement of the SO as the basis for apprehending that there's a worthwhile claim that exists, or otherwise put as saying that there's a reasonable belief in the existence of the cartel. If we turn up her judgment briefly on this, at tab 9 in the core bundle, page 14, near the foot of the page, paragraph 70, she begins with the statement, finally, in my judgment, both Nokia and Granville support the analysis set out above. And then at paragraph 71 and 72, foot of the page and over, she refers to Mr. Justice Sale's essential reasoning, which is that the claimant didn't have to be specific about the details of the cartel to put together a sufficient pleading. But here the point is that she's running together two things, because it was a judgment in Nokia about the particularity required from a pleading. In circumstances where there was just no issue about the threshold question that we're concerned about. And at 73 and 74, in her judgment, you'll see that the judge didn't accept the point that was made that on the facts, Nokia appeared to have had available to it additional material going beyond the Commission's SO. And her reasoning was that that difference in the facts didn't undermine the relevance of Mr. Justice Sale's analysis to her case, to our case. She says in the second sentence of 74, which is important, while Mr. Justice Sales didn't specifically consider the issue before me as to the probative force of the announcement of a statement of objections, his judgment made clear that the particulars of claim were drafted particularly in the light of the Commission investigation and the announcement of the adoption of a statement of objections in that investigation. And the reasoning falls down in its premise and the conclusion. Premise is wrong because Mr. Justice Sales didn't say that the content of the particulars was drafted particularly in the light of the Commission investigation. They manifestly were not. His meaning was that the Commission investigation was the occasion which prompted Nokia to draw up the particulars. And the conclusion of Mrs. Justice Bacon is wrong too, because even if she was right that the content of the particulars had been lifted from the Commission's press release or something else unstated in the Commission's investigation, the point still remains that the judge was not considering the point raised in this case today. She makes a similar point in relation to Granville. I think in the interest of time I'll deal with that in reply. It's essentially the same point. It's an even stronger case of it being a very different situation from our own. It is, though, instructive. I should say one thing about it. If you look at her reasoning in relation to Granville, she says, if you look in paragraph 76 of her judgment, that the judge there, as she is doing, was drawing, final line, the sort of inferences routinely drawn by pleaders in cartel cases. And then she gives some references to Mr. Justice Foxton's judgment, paragraphs 97, 114, and so forth. And at this point, it's instructive just to look at the very first of the paragraphs in that section, which Mrs. Justice Bacon thought supported the argument that you can infer wrongdoing from the fact of the Commission investigation. So if we go to that, that's in the Granville judgment at Authorities tab 21. And if we go in it to page 27, you have the paragraph she refers to, 97. And if you read that, this is a very different order of reasoning by the judge in that case, Mr. Justice Foxton. That was a case where it was clear and established that there was a cartel which had operated in the States and which had been described as a worldwide conspiracy. And what the judge here is doing is to reason that there's no particular basis why one might think that things would be any different in the European region, why the pricing or approach of these major undertakings would be any different at all. And that is a different sort of inference from the one that the judge was drawing here, which is to say, when a statement of objections has been announced, then one can infer the wrongdoing to which it relates. So that's all I'll say about those cases for now. Third point concerns the judge's rejection of the submission based on the judicial policy objective, when you're thinking about section 32, of avoiding the filing of speculative claims. And in her judgment at Core Bundle 9, just to recall, that's paragraphs 68 and 69 on page 14. It's a very short point. The judge implicitly acknowledged, top of the page, 68 and 69, that if there isn't any independent evidence to support a reasonable belief in wrongdoing, or from which to apprehend that you have a worthwhile claim, then if a claimant brings a damages action in reliance on the fact that an SO has been issued, coupled with the content of an earlier information request and press reports, it will inevitably lead to the need for more concrete material, at the very least, before the claim can be progressed. And it's not going to be appropriate or efficient for the damages court to order duplicative information gathering while the commission investigation is ongoing, covering the same subject matter. Indeed, it might interfere with the investigation. And that is why, to pick up on what my Lord Justice Green was saying, you are looking at the claim being stayed, if this really is the situation, if that means that time starts to run from that point. And although the judge suggested that it was only a matter of the claimant's choice of litigation strategy, it would actually be the logical and appropriate step for the court to take by way of case management. And what it does is highlight that requiring the claimant in what is in substance a pure follow-on case to file the claim earlier than when you have the decision from which you're following on serves no useful purpose. At best, it will encourage claims that sit on the court's docket without progressing, and at worst, it will encourage speculative cases and expensive fishing expeditions that may lead nowhere. That's the judicial policy point. My fourth and final point...
Can I just ask in relation to that, what happens if the Commission abandons the case at the stage of the SO, having issued a press release, done investigation? What then happens to the case? There's been a revelation, there's nothing more, there's no decision. All you have is the revelation in the press release that there is an SO. You've got minimal detail, nothing more. Does the claimant then say, well, just got to suck it and see and issue proceedings?
If the claim, I'm sorry, my lord, so if after the announcement of the SO you then receive a further news that the Commission has abandoned it,
and you still think there's a case to be made, but you've got no further information, on your analysis time hasn't run, but you're never going to get any more information, what do you do then? So it's a standalone, it's not there's no possibility of it being a follow-on.
No. On my case, the answer to that's reasonably clear, which is that if the only basis that we've been talking about for saying that you appreciate you've got a worthwhile claim evaporates, because the Commission says either we made a mistake that there was collusion, or we made a mistake that that party you want to sue was involved, you have nothing, and you don't bring a claim. And if you have brought a claim and filed one, and it's sitting on the court's docket, it's going to have to be
struck out.
Yes, or withdrawn. Absolutely right. And so, in a sense,
you may not know why the Commission has withdrawn. We all know the Commission's reasons for changing its position may be on the merits, maybe prioritisation, could be anything.
But what
you're still left in on the horns of a dilemma, aren't you? You might have a case, but you don't know.
Well, at that point, if you might have a case, it's extremely tenuous. If you simply don't know whether the Commission has abandoned its allegations on substantive or administrative priority grounds, whichever it is, you do know now that there's nothing that gives you support for apprehending that you have a worthwhile claim, which I'm taking as the metric. So at that point, it rather demonstrates that you are left high and dry, and exactly why the policy considerations that I've referred to are well founded. It does point to the fact that if you test it in this way, it's when you have a solid basis for apprehending that there's a worthwhile claim, which is when there's an announcement, there's been a decision, when there are no other, I'm taking this as a situation, there's no extraneous considerations or indications. That provides you with the basis for saying, now I know that the essential ingredients of the cause of action are present. Of course, the parties may be successful in appealing against the Commission decision to the European courts, but I have a proper basis for now investigating whether to bring a claim by embarking on the preliminaries. So, my lord, the fourth and
I think what happens now is you lose the case to Miss Ford and Mr. Jowl, who, being gung-ho, will issue proceedings.
I'm sorry, my lord.
I think your opponents will now take over the case and issue proceedings.
So, my fourth and final point, my lords, relates to something we haven't covered yet, which is the analogy between deliberate concealment cases, which involve secret cartels, and the fraud cases. At paragraph 68 in her judgment, page 14, the judge rejects the submission that there's a relevant analogy between a secret cartel case and a fraud dishonesty case in terms of the need for a pleader to be reticent and have a solid foundation in the evidence before bringing a claim. The key authority here is one judgment. It's Mr. Justice Snowden's decision in Federal Deposit, which you will find at Authorities 23. Ask you please to turn that up. And to introduce it, this case, just like our own, concerned an allegation that a claimant was out of time for bringing a cartel damages claim because it was said they've discovered the wrongdoing more than 6 years before bringing the claim. Unlike our own claim, though, the defendant sought to dismiss the action on the basis of summary judgment, not by trial of a preliminary issue on limitation. So that the defendant was alleging that the claimant had no real prospect of succeeding by relying on Section 32 of the Limitation Act. And you see that if you go to page 10 in this judgment, paragraph 24 of Mr. Justice Snowden, as he then was at judgment. Now, Federal Deposit, just like Granville, was decided before FII, which was November 2020. This case is decided in July 2020. And so it doesn't refer, obviously, to the considerations from FII, to reasonable belief or worthwhile claim or anything of that kind. So the judge is working without that subsequent guidance. Go to page 12. Please look at paragraph 32 near the top. And this is defendant's counsel, Mr. Kennelly. For UBS, Mr. Kennelly suggested there's a generous or relaxed approach in competition cases to the standard of pleading required of claimants in cases involving secret cartels. And he submitted as a consequence it would have been open to the claimant to plead a case at an early date. And then he based that proposition on the dictum of Mr. Justice Sales. On page 13, paragraph 35, Mr. Justice Snowden rejects this analogy with Nokia. You'll see that he says Mr. Justice Sales wasn't dealing with the same issue as he was concerned with because a claim had been issued in Nokia before the expiry of the limitation period. And the same point is, of course, true in our own case. Mr. Justice Snowden then went on to say that the measure of generosity afforded to claimants in pleading in this field, competition law, depends on certain constraints or protections. One of these is that defendants shouldn't be subjected to allegations of fraud or dishonest conduct without sufficient material available. You'll see at the foot of page 13, paragraph 36, with an indented quotation, he quotes his then Lord Justice Sale's judgment in the Playboy Club case, which was a case of deceit. And within that quotation, in paragraph 46 of Playboy, you first see the point that the pleading of fraud or deceit is a serious step with significance and reputational ramifications going well beyond a negligence case. And that against that context, the courts regarded as improper to make speculative claims without a solid foundation in the evidence. And then if you look at the top of page 14, Lord Justice Sales goes on to refer to, as he then was, Mr. Justice Birss's judgment in a case called Property Alliance Group, commenting on the major practical implications of alleging a fraud. And having done that, in paragraph 37, Mr. Justice Snowden cites Lord Millett in Three Rivers, who explains in a nutshell, the end of that quotation, bottom of paragraph 37, that in that sort of case, where you have fraud or deceit, the claimant has to know some fact which tilts the balance, whether it's inference or direct something. It's essentially going to be inference in the fraud case, which tilts the balance from innocence and justifies an inference of dishonesty. Then in paragraph 40 on page 15 at the top, Mr. Justice Snowden says that such principles are relevant to the case before him, which was a cartel damages case, because in practice at least, his case did involve something amounting to pure dishonesty, deceit. We rely on this in our case too. And to be quite clear, we don't say that ours is a fraud case, it's not. But what it is, like all of these secret cartel cases, is plainly a case of unconscionable conduct. It's a secret price-fixing cartel aiming to keep prices up, which is concealed from its victims, notably the major customer Gemalto, the appellant there, and, as I showed you in the recitals I took you to, concealed from the antitrust authorities as well. And in a case like this, the analogy with the standard which is demanded from the pleader in the deceit case is clear. And it's not merely the particularity of what is pleaded on which we rely, it is the substance that you must have available to you as the claimant before you make these allegations, before you apprehend in truth that there is a worthwhile claim of that nature.
There's two conflicting lines of policy here. There's one which is the one you've just identified. This is a very serious quasi-criminal allegation. Shouldn't be made lightly. On the other hand, if it's concealed, a claimant might only be able to plead a certain number of limited facts, and courts are generally sympathetic to the fact that they're facing, a recalcitrant defendant who won't disclose the SO. So you've got two conflicting policies here.
My Lord, you're absolutely right, and that is a point that Mr. Justice Snowden directly raised in this case. I haven't taken you to that, but he says, it's put to me that there's a measure of generosity in pleading these sorts of cases, and that as an inference from that, because of this generosity, it's possible to have discovered the claim in substance at an earlier point, because you can be very generous in what a pleader needs to know and plead. And what he said was that point needs to be tempered by the other policy point, that in a serious case of at least fraud in that case, there are various protections that Mr. Justice Sales also referred to. And one of those is that given various features of a fraud case, and I went through some of those, one needs to have a solid foundation in the evidence in relation to the essential ingredients. So there's a difference. For the essential ingredients, yes, you must have a solid foundation. When it comes to matters like which subsidiary was it, what sort of price fixing was it, did they have meetings that covered this particular type of device or not, all of that you can have generosity in relation to. But for the basic ingredients of the case, he was insistent that one needs to have a solid foundation in the evidence in the sense explained by Lord Millett in Three Rivers, that you've got enough there that means that what I see in front of me is not merely as consistent with innocence as with guilt, but there's something that tips the balance. And we rely on that in this instance too. It's not fraud, it's unconscionable conduct, because it's not being said, at least at the moment, that these defendants went out and actually actively lied to customers or anything of that kind. It was a secret price fixing arrangement. But what it was unconscionable conduct. And in those circumstances, it makes sense too to say, well, I now know that the Commission has issued an SO. Given all the circumstances that I am reasonably aware of, I, Gemalto, I do not know whether the infringement exists, happened or not. I consciously have no idea whether that will be shown to be the case or not. And so adopting the reasoning of Mr. Justice Snowden here, there's nothing that tips the balance for the inference to guilt. And just as in the fraud case, but for a different reason, he said that there should be, in that sort of serious case, something that tips the balance. We say the same should be true here. You don't have it from the mere announcement of the SO, because that only tells you there is the possibility that it will turn into an infringement decision, a finding, and a possibility that it may not. So, my Lord, in view of the time, I will only deal very, very briefly with ground 2 and then make a brief conclusion. The final submission concerns ground 2 of the appeal. The judge, you've seen, had 2 reasons for rejecting the submission: that Gemalto didn't have a reasonable belief in the cartel having taken place in a particular time period. And I use the phrase there, reasonable belief, because you've seen that the judge herself also picked that up and described it in paragraph 51 as the standard she should apply. And her first reason was that our submission would place an impossible burden on a standalone claimant. You have to be precise about the time period when a cartel took place, at the time when you engage on the pleading. And that was a misunderstanding in my respectful submission, because the submission is not that when pleading a cartel infringement, you need precision about the dates when it started and when it ended. It's always been the case that it's acceptable to say it took place at least between date X and Y, and we say it caused loss in consequence to us. The point is that you need a solid basis, some proper basis, for picking date X and date Y. And in the present case, there wasn't a solid basis. Had that request for information, the factual information request. And so again, the judge conflated the requirements for pleading, saying that a great deal of generosity is afforded, with the requirement of substance, that you must possess enough to know that there's a worthwhile claim. Her second reason was that although it be necessary to infer the dates of the cartel from the ambit of factual information requests which had been served, that was okay, because the need to draw inferences is likely to be inevitable in a cartel case. That's her reasoning. It's flawed because the issue Gemalto was raising was not about the use of inferences generally. It was about the permissibility of drawing an inference from the material in this case. And a damages claimant can't properly draw an inference that the Commission's, even that their preliminary view is that an infringement took place in a time period which happens to have been covered by a historic information request. The Commission could have asked questions entirely about a comparator period, after or before the infringement. And furthermore, the information gathering might not even have involved holding a view on any suspected period of infringement. They were in the information gathering mode. Still less can one draw an inference amounting to apprehending that you've got a worthwhile claim that an infringement objectively happened in a time period covered by an information request. So, my Lord, for all those conclusions, we respectfully ask this appeal be allowed on both grounds. And I conclude with these 2 points to summarise the debate on ground 1. Number 1, that discovery of the possibility of the collusion, which is what you're alerted to by the Commission's statement of objections being announced, is not the same thing as discovery of the collusion. And point 2, that an appreciation that there is something to investigate is not an appreciation that one has a worthwhile claim in damages. It's only once we say you've got the material showing that there is a worthwhile claim, because at least the essential ingredients of the cause of action have been established, that you then proceed to investigate all of the details needed before you can actually plead and lodge a claim. My Lords, unless there are any questions, those are my submissions.
Thank you very much,
Great.
Mr. Tennant. Mr. Joe.
May it please your lordships, I've already explained the division of labour between myself and Miss Ford, QC. I should note that, of course, in relation to issue 1, precise dividing line between issues of law and issues of fact on an appeal which must be on a point of law is not entirely clear, and there may be some overlap. But nevertheless, I think that our submissions will be as seamless and as unrepetitive as we can manage them. So that you know where I'm going, I intend to deal with my submission subject to your preferences in 4 parts. First of all, I wish to address head-on certain of the key points that my learned friend has made and to explain our position in response to them. Then I want, if I may, to go back to some of the first principles relating to the statement of claim test and the approach that this court is bound to follow in relation to section 32.1 and also, of course, to the test in FII. And to that end, I will have to take you, I'm afraid, back through some number of cases of this court and of 1 or 2 courts below. And I do apprehend that a number of those will be very familiar, so you will have to bear with me. But I need to go through them, I'm afraid, because my learned friend has made a number of what might be called 5-minute points, which is to say points that take 5 minutes to make, but then take about 15 minutes to show why they are incorrect. And then next, and in light of that, and in light of those authorities, I then like to address my learned friend's arguments as to why he says it was wrong for the judge to place reliance on information derived from the statement of objections or from the commission investigation more generally. And I wish to deal with that in a bit more detail in light of those authorities. And then finally, I will seek to deal with some of the particular points that my learned friend has made. The suggestion that, for example, that a claim, a competition cartel claim involves an allegation of unconscionable conduct, and that on that basis a different pleading standard should apply. His related argument that there is a policy argument that this court should not encourage speculative claims or claims that would be stayed immediately, and the significance of the denial on the part of Infineon. Could I start then just with dealing with certain points made by my learned friend? The first is the nature of a commission statement of objections. And my learned friend submitted that when the commission issues a statement of objections, the commission doesn't consider there's a reasonable basis for belief that an infringement occurred. He said they would never say that. Well, I'm afraid we don't accept that premise. And it's not in accordance in our submission with how the commission itself regards a statement of objections. And to show you that, could I take you to volume 5, please? Forgive me, you don't. Tab 53.
We have neither volume numbers
Five,
nor
no.
tab numbers.
Ah,
We do have electronic page.
well,
1407.
I'm most grateful.
Interestingly, my Lord's page numbers are not the same as mine,
Oh, well, that's a pity.
but they're close.
I'm afraid
What are you looking at?
it is the Commission's notice on best practice.
Right.
And if you could go in that document, if you have it, please, to paragraph 82.
Which tab did you think it was?
It's tab 53,
Oh,
page 16 of the tab.
okay. Yeah.
And we see that it's headed the purpose and content of the statement of objections. The statement of objections sets out the preliminary position of the Commission on the alleged infringements of Article 101 or Article 102 after an in-depth investigation. Its purpose is to inform the parties concerned of the objections raised against them, with a view to enabling them to exercise their rights of defence in writing and orally. It thus constitutes an essential procedural safeguard which ensures that the right to be heard is observed. The parties concerned will be provided with all the information they need to defend themselves effectively and to comment on the allegations made against them. So it is correct to say that the statement of objections is a preparatory document, but it is also one that arises at a particular stage in the Commission's investigation, and it serves a particular function. It resembles in form a draft of the final decision, and the purpose is to put the addressee on notice of what the Commission has, following an in-depth investigation, decided to now formally allege against them. To use the language of the Court of Justice in the Troyhan case that Ms. Ford will take you to, the addressee of a statement of objections has the status of a person charged. It is a formal charge. And if you look across to paragraph 92 on the opposite page, you see access to file. Could I read that to you, please? It says the addressees of the statement of objections are granted access to the Commission's file in accordance with Article 27 of the regulation, so as to allow them to effectively express their views on the preliminary conclusions reached by the Commission in its statement of objections. So we accept, of course, that the Commission may, in due course, choose to alter its position. But nonetheless, the statement of objections constitutes the preliminary conclusions of the Commission after an in-depth investigation. And that is the basis on which it then alleges an infringement against the addressees. So that is the first point we would wish to correct. It is a statement of the Commission's views, indeed of their conclusions, albeit preliminary. Now, the second point that my learned friend makes is that he focuses in on the language of reasonable belief and a reference to a worthwhile claim in the case law. And he put that together with the requirement for a statement of truth, and he sought to interpret that so as to suggest that put together it meant that the requirement under section 32(1)(b) is that a concealment will not be discovered unless and until a reasonable claimant in the claimant's position would consider it likely that they had a good claim, or at least that it was more likely than not that each essential element of the claim took place. But when one reads the authorities, and I will take you back to them, I'm afraid, and here I include not only FII, but also the authorities on the statement of claim test, they do not go nearly that far. Even under the statement of claim test, the bar is a very low one. As my learned friend acknowledged in response to a question from the Master of the Rolls, the actual test is at most whether a reasonable person could have a reasonable belief in the essential facts, not whether a reasonable person would positively be likely to have such a belief. And that's why the test actually equates to asking whether there was sufficient material properly to plead, in the sense of are there proper grounds for pleading facts, and are any inferences pleaded reasonably open. And what section 32.1 means is not, therefore, that a pleader would positively believe that every element of the claim was likely, and hence that it had a strong claim or a good claim. It means that a pleader has enough in their possession to plead a prima facie claim.
Why are we concerned about pleaders? We're talking about discovery of concealment.
Well, I think that it's fair to say that there is some connection between the two, because, as His Lord Justice Green pointed out, the section does talk about the facts relevant to the right of action. So it's the discovery of those concealed facts that, if you like, gives you uncovers the concealment.
There's nothing in FII that says that you need to be able to test it by reference to the pleader.
No,
it's completely the reverse.
No, indeed, it's the preliminary. I will come to FII, but if you like, I'm putting the bar higher for us.
I know that's very unhelpful, Mr. Jowl, to me. I respectfully say so, because the bar is where it is. Putting the bar higher simply fails to establish what the test is that the court is going to apply in future. And if I may say so, accepting before the judge that there was a higher bar than there really was has led probably to this appeal.
My Lord,
she accepted your entreaty. Well, if I can reach this high, then I don't have to worry about reaching this high. But for this court, it's very dangerous for us to approach the matter on that basis, because other people will then say, and there will be cases, even if the judge was right, there will be cases that fall between the two bars. So we need to establish what, as a matter of law, in the light of the Supreme Court's extremely detailed and well-reasoned judgment, the bar, what the bar is, and then apply it to these cases.
My Lord, I accept that. One point I should correct.
So, I mean, looking at the law backwards,
yes,
through the lens of what may have happened years ago, is anyway, I find pretty unhelpful. I'd like to look at the law from where it is today, and then see if I find anything in the old cases that changes that, because I think you will find, if we look at what cases the Supreme Court looked at, they looked at all of them.
My Lord, may I just correct one point, which is this. The point was argued below. We argued that the proper approach was the FII approach.
Yeah, and the judge virtually accepted that.
Yes. And I'm content to argue that.
So does Mr. Turner, by the way.
Yes. Well, my Lord, I'm content to argue that again in front of you today. Of course, Mr. Turner may say, well, there should have been a respondent's notice on this point.
Well, he doesn't say that.
But he doesn't.
He hasn't said that. So we don't need to worry about it.
I'm content to take that. But in our submission, there isn't perhaps as much as one might at first think between the statement of claim test properly applied and the FII test. And that is a point that is important. And the reason that
there may or may not be, but
well, indeed.
The statement of claim test is not supported by FII. FII tells you what the test is to apply to section 32.1a and 32.1c. It doesn't purport to tell you what the test is to apply to 32.1b. However, it gives a very clear indication, since it's construing the words on discovery that are a proviso to 31b, that the test might be the same as 31a or c, adjusted for the fact that it's about concealment.
Well, my Lord, and we gratefully said that below, and we say that we submit that again in front of your Lord.
And actually, to be entirely fair to Mr. Turner, he hardly disagrees with that. He just says that the way they put it in FII is less binary than I wanted to put to him, and that you need a worthwhile case and a reasonable belief in a worthwhile case.
Yes.
And you can't have that here, which I mean, being unfair to him, I'm saying reintroduces the statement of claim test by the back door. But that's what he says.
My
So
Lord,
he's not pushing back on that.
my Lord, well, we respectfully submit that, as we said below, that the proper approach is the FII test.
Yes.
We also submit that in fact, two things. One, that one thing must be clear, and that is that the FII test is not a more difficult test than the statement of claim test.
No, that's
That is clear. And secondly, we say that that Mr. Turner's submissions, the construction that he seeks to put upon the requirements for reasonable belief and worthwhile claim, the way he seeks to interpret or dial up those phrases taken out of context, is not just contrary to the proper application to the FII test, it's also contrary to the proper application of the statement of claim test even. And that's the point that I did just want to deal with, if I may. And it's important that, and he, in particular, he sought to put it together with the requirement for a statement of truth in relation to the statement of claim test, in order to create something really which would be very potent and would quite distort the meaning of the proper application of Section 32.1.
Well, he said that the approach that Mr. Justice Foxton adopted in Granville was still good law, effectively.
Yes.
And you say, I imagine, it's not.
Well, may I take my Lord? Yes.
Yeah. And I mean, you know, to be fair to Mr. Justice Foxton, it's an absolutely fantastic judgment in Granville, and I upheld vast tracts of it in DSG.
Yes.
And it's a tour de force. But the bit about this particular aspect is really, unfortunately, inconsistent with FII.
Well, my Lord, is it? Because my learned friend was, in my submission, very selective.
You say he misread it.
He took you to very selective parts of it. And if I could take you back to it now to show you that. It's in tab 21, the Granville judgment. And if we go back to, if I may, to paragraph 24, my learned friend took you to the beginning sentences of paragraph 24.
I mean, just so you don't spend too much time on this, some courts of appeal would be rather less indulgent about dwelling in great detail on a first instance judgment that has been falsified partly or anyway changed in emphasis by a Supreme Court judgment, when we're really not bound by this in any sense whatsoever.
I see that, but I feel I have to...
Well, still then, take it nonetheless, take it quickly.
My Lord, I'm grateful for the indulgence. In any event. You'll see in the second half of paragraph 24, he makes an important observation, which was not read out. He says, there will be cases where the facts necessary to plead a case will all be in the claimant's direct experience. In that case, this is in Johnson, the fact that the claimant had been falsely imprisoned. However, there will be other cases, of which the present is one, where the essential facts are matters of which the claimant has no direct and immediate knowledge, but will seek to establish at trial by relying on disclosure or admissions by the defendant, evidence derived from third-party sources, and inferences from other facts. And he then goes on to make a comment that is wholly consistent with FII, which is that the concept of discovered cannot be equated with knowledge of the fact. And then he quotes at paragraph 26 what is the key touchstone of the statement of claim test, which is Lord Justice Newberger's comment in Law Society and Sefton. As the judge said, a claimant does not discover a fraud until he has material sufficient to enable him properly to plead it. The key word there is enable him. And my learned friend then took you to paragraph 28 and to paragraph 29. And he showed you that Mr. Justice Foxton had divided the requirements of having to properly plead a claim into three parts. The professional obligations that attach to making allegations of a particular kind. The fact that the pleaded case mustn't be one which would be struck out on the basis that it didn't have a sufficient evidential basis or was not sufficiently arguable. And three, the pleading must be capable of one being supported by a statement of truth. My learned friends sought to stress that they all added something, and all were requirements. But what he did not take you to was to paragraph 37 of Mr. Justice Foxton's judgment, which you'll see 2 pages on. Because in paragraph 37, having cited from the Chancellor in Arcadia Group, Brands, and the point that affected, and from Mr. Justice Simon in Arcadia, that the generous approach to pleading competition claims cuts both ways, in that it also applies when one is considering limitation, he then says this: so far as the requirement for a statement of truth is concerned, for section 32(1)b purposes, the issue is to be tested by reference to the material that could have been available had reasonable diligence been exercised. Further, where the matters alleged are not within the direct knowledge of the party on whose behalf the statement of truth is to be made, but involve drawing inferences and assumptions on the basis of the pleaded facts, a statement of truth can be given provided there are proper grounds for pleading the facts and the inferences drawn from those facts are reasonably open. In this context, therefore, I do not believe that the statement of truth requirement adds any further element over and above that for a properly formulated pleading, where the pleader has sufficient grounds to make averments and draw the inferences on which the cause of action depends.
He was talking about a non-strikable pleading.
Indeed, exactly. So it all boils down to whether the claimant could have pleaded a claim that wouldn't be struck out in his approach. And we say that if you apply that here, this is actually a very simple appeal indeed to resolve, because if this claim had been pleaded on the basis of the Commission's provisional conclusion in the statement of objections, there is simply no way that any judge of first instance would have struck that claim out.
Well, they'd have been adventurous if they had.
Indeed they would.
They'd have been saying to the European Commission, you've spent 4 years investigating this. You come to the conclusion there is a charge that you can legitimately, honestly, and appropriately levy against major corporations whose financial well-being is no doubt badly affected by this publication of this statement of objections.
Yes.
And we are saying we're going to strike out the claim that might follow from that.
Yes. Indeed.
I mean, that's what I put to Mr. Turner this morning, early.
Yeah, I think a legal representative might be hard-pressed to advance that without misleading the court. If you know what's in the SO and you turn up and say that the other side's pleading is exiguous, in circumstances where had you disclosed your SO,
yes,
you wouldn't have been able to advance that case. I think you'd be in some difficulty.
yes, indeed. And that really is the beginning of the end. And that is the essence of really the reasoning of the judge below. If I could just briefly show you that, because it is I think that learned very rightly described as the core passages in the judgment. It's in paragraphs. Really starts at paragraph 59. And you see that the judge starts by saying that, noting the paragraph 82 of the best practice notice, makes clear that it constitutes the preliminary position of the Commission after an in-depth investigation. As I've shown you, it's actually 91 shows you it's the preliminary conclusion, even a bit further than that. And she says a potential claimant can properly infer that such a position doesn't represent merely speculation or suspicion, but is founded on evidence that's been gathered during the course of the investigation. And she notes that investigation will necessarily include the gathering of information and evidence and any relevant third parties. In many cases, including the present, the investigation will include dawn raids at the premises of one or more of the undertakings. And then she goes on to cite further aspects of the requirements of a statement of objections. And she says in paragraph 62, by the time that the Commission adopts a statement of objections, it will have a far fuller evidence base for the infringements alleged than would normally be available to an individual claimant who brings a standalone cartel damages claim. It will not have the extensive investigatory powers of the Commission and will not have had the benefit of disclosure. And I will, if I may, show you at least one semi-standalone claim which is of that nature. In those circumstances, it would, in my judgment, be entirely reasonable for a claimant to rely upon the Commission's announcement of a statement of objections as a base for a belief as to the existence of the cartel described in that statement of objections. If the Commission decides that the evidence in its possession is sufficient to form a preliminary view that infringement has occurred, it's very difficult to see why a claimant cannot rely upon that decision as giving rise to a prima facie case that can be pleaded in a claim in domestic proceedings. Subject, of course, to the question of whether the claimant's press release and any other available information contains enough material for the cartel to be pleaded with sufficient particularity, especially as the identifying elements are set out above. And I'll come back to show you what those identifying elements are and why each one was satisfied in due course. But that's the essence of the issue before you. And it's actually, once one conceives of it as really a strikeout issue, it's not actually a difficult one. My Lord, if I may, I'd like to just
Is
go
the
back.
only ones of his key points that you want to knock on the head?
There are so many.
No, but you said you had a number of key points. I
Yes.
thought it would be, a number would be more than two.
Yes, my Lord.
Maybe not.
I did. There is perhaps there's perhaps one other key point that I can address you on straight at the outset, and that is the question of the policy point, which is that this would lead to speculative claims, and that such a claim would be bound to be stayed. The first point I would make about the way of putting that any claim, if made, would have been bound to be stayed, is that it presupposes the point that I've just made, which is namely that it would not be struck out. And that, in a sense, gives you the whole answer to the question before you. Secondly, the fact that a claim may be stayed as a matter of case management is neither here nor there when it comes to the application of Section 32(1) of the Limitation Act. One can't have.
Backtrack for 1 second.
Yes.
The strikeout point. In some respects, the courts are loath to take the view that a writ has been issued prematurely in cases like this, so they grant an indulgence. Is that necessarily the same test as saying it's triggering limitation? The courts are very reluctant to strike this out because the defendant is, according to the Commission, a wrongdoer, won't provide the SO. Yes. You've got to have sympathy for the claimant, and you don't want to unnecessarily waste costs and time when this is going to proceed come what may. Is that really applying the same set of principles?
It must be, because there must be coherence in the law. What one can't have, and this really is established by the Arcadia judgment in the Court of Appeal and indeed first instance, that what one can't have is one test when it comes to whether the claim is pleadable for giving indulgence to a claimant, and then another test when you are applying the same standard, the same test, the statement of whether the statement of claim would be struck out when it comes to limitation. It must, one has to have some coherence and consistency in the law, and that is clear, as I'll show you from the judgments in Arcadia. And what one particularly can't have in my submission is what, if I remember rightly, Mr. Justice Foxton put it in the course of argument in Granville, is competition law exceptionalism, which is to say that somehow competition law claims are all special, where one departs from the usual standards on limitation and other rules. The rules must apply consistently to competition claims. And if the courts say there is an indulgence granted to pleaders of these claims when it comes to pleading them, then that must also apply when it comes to Section 32. But in addition, I would say that the concerns of policy are vastly overblown. And they are overblown precisely because, as the court has observed, one has 6 years to bring these claims. And so actually, one can very well say, well, to clients, yes, your limitation clock is ticking now, the statement of objections has been announced and all of the information on which you could bring a claim is out there, but you would be well advised to wait for the Commission decision. And in the ordinary course of things, that will still give pleaders plenty of time to bring their claims. And indeed, even if in the most extraordinary circumstances that the decision was not brought within 6-year period, they still have the special limitation period under the Act to bring for 2 years to bring a special follow-on claim. So there's no real policy concern here, and there wouldn't be any. There should be no great concern over any great flood of claims being brought prematurely. Those are certain points I'd like to just knock on the head at the outset, if I may. If I could just come back to first principles. The reason I do is because a theme running through my learned friend's submissions, both written and oral, was the suggestion that a claim brought on the basis of the information known to the claimants before the Commission decision would have been, as we've discussed, jumping the gun, as you might have put it, and that a reasonable litigant would have waited before bringing a claim on such a basis. And allied to that is his suggestion that this policy concern that the courts shouldn't find that time begins to run for limitation purposes unless and until a well-advised litigant would have perceived and brought what he called a worthwhile claim. And that is just not how the courts have approached Section 32(1). The courts have never been concerned to identify when a litigant would have been best advised to have brought the claim in question, or when a well-advised litigant should have brought the claim. They've always been concerned with identifying when sufficient information was actually or constructively known to the claimant, such that a prima facie claim could have been brought. The claim might have been a weak one that had been brought. It might have been likely to be defeated by a valid defence when it was brought. It might have been denied by a defendant when it was brought. None of that is decisive, or even really matters. What matters is whether it could have been pleaded without being struck out. And one can see that if one goes back to the very early cases that I know the court will be very familiar with, of Johnson and of Mirror Group. Now, of course, neither of them relate to cartel damages. But I would just remind you, if I may, of the circumstances in Johnson. In Johnson, someone was imprisoned, but they didn't know until much later on that their imprisonment was unlawful. And if I could ask you to look at the judgment, it's in tab 6. Forgive me, I'm not going to ask you to go to Johnson itself. I will take you to the passage from Johnson, which is quoted in Mirror Group, which is in I believe in tab 2. And if I could invite you to go to, it's page 6 of my bundle. In the judgment, it is page 136. The judgment of Lord Justice Neal, who was in both cases. And in order to spare you from me reading out, could I just invite you to remind yourselves of the content from letter G on page 136 to letter G on page 137.
Yeah.
So one can see from Johnson that the claimant could have said, well, I didn't know that I had a worthwhile claim until I knew that my imprisonment was unjustified. But that's not the meaning of worthwhile claim in this context. What's meant is, as the judgment makes clear, is was there sufficient to give him a prima facie right of action? And there's no suggestion in the judgment that the pleader should have pleaded at that time. Of course not. And similarly, the facts in Mirror Group itself are perhaps even more striking. So you'll recall that the facts in that case was a custody battle. And the mother had taken the children abroad to Australia. Father brought the matter before the family court in this country. And there was a hearing. And the father made a number of completely false allegations at a press conference after court, in which he alleged that the mother was in a drug scam. And those defamatory allegations were repeated in the press, including in the Daily Mirror. The Daily Mirror published the allegation, and it came to the attention of the claimant, the mother, who was then in Australia. The report in the Daily Mirror, however, didn't make it clear whether the words were spoken outside court or in the course of court proceedings. So the mother called the editor of the Daily Mirror, and she was told that they were just repeating what her husband had said in court. Now, if that had been true, and the matter had been said in court, then of course privilege would have applied, because there would have been a report of court proceedings, and no action in defamation would lie. So the mother brought no claim. But later on, years later, the claimant discovered from a letter she received from the English court that the husband had said nothing in court about her having any involvement in a drug scam. And she could therefore infer at that point that the comments were made out of court. But she only had received that information in 1993, long after the primary one-year limitation period for actions in defamation had expired. And she then issued her writ within 1 year of receipt of the judge's letter. And if one goes to page 138, and if I could invite you briefly to read from 138, just below letter C, to 139, letter B.
Yeah.
So one sees from these cases the sheer rigour with which the court applies Section 32(1). It doesn't look at whether the claimant should have issued proceedings at the point in time when the clock starts ticking. It looks at whether they could have brought a prima facie case that wouldn't have been struck out. Now, and so it may well be that a claimant in a particular case is much better advised to wait until further evidence turns up to support a claim or ensure that a particular defence is not available. But none of that is relevant to the point in time when time starts to run. And these cases have been essentially endorsed by the approach of the Supreme Court in FII, which also stresses time and time again that what matters is when the claimant was in a position either to embark on the preliminaries or at most to plead its case. It's not concerned with when the claimant knew true position with certainty. So we can perfectly well accept that it might have been prudent or sensible for the claimants to choose to wait until they had the greater certainty and security of the Commission decision. But that consideration is irrelevant to the application of the statement of claim test and certainly irrelevant to the application of the FII test. Now, I said I would show you some cartel cases, and I want to take you, if I may, to one that you might not have seen, which is the Toshiba Carriers case, at first instance, in front of the Chancellor. That's in volume 1 at tab 9.1. And if I could show you
You said
paragraph
tab 9.1.
9.1.
Oh, see, that's not in the bundle, is it? Yes. We got it separately.
I'm told it's page 168 of the PDF bundle, the electronic bundle.
Okay, not in mine, it's not. Okay, carry on.
Does your Lordship have it? It will be.
Not at the moment, but I will in a moment.
Perhaps we can pass up a copy.
No, I don't need a copy. Yeah, you carry on.
Perhaps if we can hand up copies of them. Thank you very much. My Lord, might I provide on this exceptional basis paper copies? Because
I've got it on the screen.
Oh, you've got it on the screen. Forgive me, my Lord. So sorry. Paragraph 3. You'll see that there are a number of they're identified as two groups of defendants. First are the UK defendants, KME Yorkshire, Nemco and WW UK. They are the UK defendants. They are seeking orders striking out the claim against them on the grounds that there's no reasonable grounds for bringing it, or for reverse summary judgment. And all of the other defendants are challenging jurisdiction. So this is a case where you have three anchors, two in one group, Nemco and WW UK, and another KME Yorkshire in a different group. And if you could go, please, to page 5, you'll see that the judge starts to recite the content of the Commission decision. And if you go on to page 9, please, we see the operative part of the Commission decision, and we see that none of the UK defendants were themselves addressees of the Commission decision. And you'll see in paragraph 17, it notes, of the UK defendants, only Nemco is mentioned by name, but then only as a subsidiary of the Fifth Defendant. Although there are numerous references to the KME group, KME Yorkshire is never mentioned by name, nor was it suggested that there was any necessary implication of a reference to KME Yorkshire in the reference to the KME group. The claim against the seventh defendant has been discontinued. As in the case of KME Yorkshire, there is no mention of WW UK, nor is it suggested that the references to the parent group are by implication to be read as references to this defendant. So no references in the decision to speak of, other than one as a subsidiary, to the UK defendants. And they are of course, not addressees of the Commission. One then sees over the page, starting in paragraph 18, it refers to the particulars of claim, which are in somewhat vague terms. And if one goes to paragraph 24, one sees that it was clarified in correspondence that there was intended to be an allegation of participation in the cartel by the UK defendants. You see that in the middle of paragraph 24. They were involved in, in correspondence, the claimants say that NEMCO and WWUK were involved in and parties to the anti-competitive practices and in any event liable for their acts of implementation. And that contention is repeated by the KME defendants. Now, there's a separate issue in this case, which we're not concerned with, which is whether the defendants could be held liable on the basis of so-called principle in provimi, on the basis that they were part of the same undertaking as the addressees that were found liable. But we're not concerned with that aspect. But if one could go, please, forward to paragraph 31, which is on page 16, one sees that with the submissions of counsel for KME Yorkshire and for the other defendants, that there was no sufficient allegation that the defendants were part of an undertaking or that they implemented or any such arrangement. And then the judge notes, these submissions were founded on the premise that the claim was only a follow-on claim. That's to say, one founded and brought to enforce the conclusions of the commission as expressed in the decision. In his oral submissions, counsel for the claimants indicated that this assumption was not correct. He contended that claim as pleaded included a standalone claim, that is to say, one based on the direct effect of Article 101 and its infringement. And so the question was whether, first question was whether claimants had adequately pleaded participation in the infringement by the UK defendant. And if you go forward to paragraph 36, please, on page 19, you see that there's reference there to witness evidence on behalf of the defendants saying that they had not participated. So we see KME Yorkshire relying on the witness statement of Mr. McLean, the managing director of KME Yorkshire, submitted that the case on implementation had no real prospect of success. There was no sufficient allegation of knowledge, and anyway, the actions of the defendant were only as agent. As such, it wasn't in a position to influence the price or other terms on which the industrial tubes were supplied in the market, and didn't engage in any relevant activity on its own behalf. In the case of NEMCO and WWUK, counsel submitted that there was no sufficient allegation of knowledge and no acts of implementation. Each of these defendants relied on witness statements adduced on its behalf and substantially unchallenged by any witness statement adduced by any claimant. In the case of NEMCO, it was contended that there was no evidence that it ever supplied any of the claimants with LWC, and in any event, it set its own prices without any consultation with its parent company. And in the case of WWUK, the evidence demonstrated that it never supplied any of the claimants with LWC in the relevant period, but acted solely as agent for its parents, the Fifth Defendant. So complete denial of any participation in the cartel, and no knowledge, no participation. And at 37 and 38, there's a debate between counsel as to whether there was sufficient to sue the UK defendants for participation or implementation. And if I could then ask you please to go to paragraph 41, and you see that the Chancellor concludes that the matter there was a proper pleading of a standalone participation claim. And then at paragraph 45, on page 22, we see that he concludes that the claim would not be struck against the UK defendants, would not be struck out. And then from paragraph 47, the Chancellor considers whether the claim against them has a real prospect of success. And again in paragraph 48, he again, and 49, he concludes with regard to KME Yorkshire that they are part of the same undertaking and they implemented or arguably implemented by selling the goods in question, and that sufficed to give an arguable case against KME Yorkshire. And then, if I may, I would read to you what he says about the other two UK defendants in paragraphs 50 and 51. He says this: in the case of Nemco and WWUK, there is a witness statement from Mr. Weiler. He states that Nemco didn't sell any of the product to any of the claimants and set its own prices. He denies it was implicated in any information exchanges. In addition, there's a witness statement from Mr. Herold, its managing director. He states WWUK didn't sell any products to any of the claimants. He states that, to the best of his information, it didn't participate in any information exchanges with competitors. Accordingly, he submits that there's no basis for any allegation that this defendant knew of or played any part in the implementation of the offending agreements or concession practices. There is no evidence from the claimants in response to that of Mr. Weiler and Mr. Herold. But there has been no disclosure. As the Court of Appeal pointed out in Cooper Tire, the strength of the claimant's case cannot be assessed, let alone particularised, until after disclosure of documents. The fact that the claimants do not have evidence to refute that of Mr. Weiler or Mr. Herold does not enable me to conduct a mini-trial, let alone predict the outcome of the actual trial. The fact is that these defendants too were part of the same group and were involved in the same economic activity as the undertaking found by the Commission to infringe Article 101. In my view, these defendants have not shown that the claim against them does not have real prospects of success. So even though in that case the Commission decision doesn't mention these defendants, even though they put in evidence saying they hadn't participated in the cartel, nevertheless the Chancellor says this is a claim that cannot be struck out. Now that shows just how generous the courts have been to these kind of...
Has that been approved anywhere?
My Lord, it's upheld by the Court of Appeal.
It was upheld.
But not this, I have to confess, not this part, because the claims against this group of defendants was settled before it reached the Court of Appeal. But it is a judgment of the Chancellor.
Well, it's an interesting example.
Indeed it is, my Lord. And we say it really illustrates that if Gemalto had pleaded that my clients, Renesas, were involved in a cartel on the basis of the Commission's a statement of objections and all that, the information that derived from it in the public domain, that would have been, such a claim would have been struck out or summarily dismissed, is just impossible to square with the sort of approach that we see in a case like this. I should take you to the same, the judgment of the Court of Appeal.
Do we need the judgment of the Court of Appeal?
Well,
it doesn't specifically approve this, but
what it does approve is Nokia. So I'll very, very quickly show it, if I may. It's a tab 12.
What, the part in Nokia where the judge effectively applies the test of generosity?
Yes, indeed. Indeed.
You want to just give us the reference?
Well, I will, my lord. It's paragraphs. It's really the critical parts are paragraphs 31 to 33.
And that's tab.
And that's tab 12. And finally, if I may show you the Arcadia case very briefly, because I know the court is very familiar with it. In tab 2. Forgive me, tab 16.
Why are we looking at Arcadia?
Well, really simply to show the point about that what I would call the cuts both ways point. That the generosity that is you see exemplified in cases like Toshiba and Nokia is also applicable when it comes to Section 32. And so I think it is relevant to go.
Okay, which bit? Is it the Court of Appeal?
It's both first instance and Court of Appeal. Perhaps the statement is perhaps clearer at first instance. So if
paragraph.
Which
paragraph?
My Lord, paragraphs 95 and 101 to 103. And I would just, and then on the same basis, Arcadia in the Court of Appeal, which is in tab 17. And if I could invite you to look at the judgment there at paragraphs 49 to 51 and at 60 to 64. My Lord, if I may very briefly deal with Granville and Nokia, though of course they are both first instance judgments. I think in relation to Nokia, don't accept my learned friend's characterization of that case. The important point to note in Nokia is that there were two particulars of claim that were being considered by Mr. Justice Sales in that case. There was the original particulars of claim and the amended particulars of claim. And if one turns to the case, perhaps we should go through this in a little bit of detail. It's in tab 11. And one sees that in paragraph 7 that the original particulars of claim were issued in November 2009. And one sees that then an amended particulars of claim is later drafted in light of disclosure that's obtained in the United States. But what is fully an issue is whether the original particulars of claim was or wasn't demurrable. Because if it was demurrable, then the amended particulars of claim introduced a new cause of action. And we see that Mr. Justice Sales notes, if you see paragraphs 17 to 20, see he refers to the the issue by the EU Commission of an announcement of its extending of its statement of objections. And we see in paragraph 20, it seems that it was particularly in light of the Commission investigation that Nokia drew up the particulars of claim and issued its claim form in November 2009. The particulars of claim set out the background and referred to the Commission investigation with the obvious intention that if the Commission issued a decision finding that the defendants or any of them were guilty of violation of Article 101, that would be pleaded in due course and would found the basis for a follow-on claim by Nokia against those defendants. Then, if you see in 19 to 20, forgive me, we've looked at that already, at 22, we see that the Commission then issued a decision, but it was the decision didn't cover the sort of small LCDs for mobile telephones that were relevant to Nokia. And you then see, that then it recites in 25 and 26 how they then plead an amended particulars of claim by reference to the United States disclosure they obtained in the United States. And you see in paragraph 30, you see that Mr. Justice Sales says, if I came to the conclusion that the original particulars of claim did not include properly pleaded causes of action, or that the amended particulars of claim added new causes of action, it was agreed that I should issue a judgment to that effect, and the parties would take stock of the position. So the judge is directly considering whether the claim, the original particulars of claim, was or wasn't properly pleadable. And if you look at paragraph 33, one sees he recites the claim form, which is in very broad terms. The claimants claim damages for losses in connection with purchase of LCDs between the dates incurred as a result of the defendant's infringements of Article 81. And then over the page we see the particulars. And you see, I'm not going to invite you to read them out, but it's very clear from the pleadings that an important aspect on which the claim is based is the Commission investigation and the Commission SO. And indeed, as against some of the defendants, it just seems that there is no allegation other than that based on their involvement, the fact that they are under investigation by the European Commission.
Cumulatively, there was a great deal more than just the SO in that case. How far does it really provide guidance? It wasn't a case where I remember both you and I were roundly thumped by Mr. Justice Self on that occasion, along with others probably in this room. But there was a lot of evidence came in, for example, the Department of Justice from the US. It wasn't a bare minimum case, was it?
Well, there was Department of Justice against at least some of the defendants, but not I think all. And the way that it's pleaded, you'll see in paragraph 38. And if you read paragraphs 39, you see it says the defendants, all members of undertaking, it alleges that have been parties to secretive anti-competitive agreements. The defendants either participated in and/or implemented the arrangements. They say that they can't particularize all of the names, and they say that they give the best particulars they can. And if you look in paragraph 46 of the pleading that's quoted, they say one or more companies from each of the undertakings party to the arrangements have during the cartel period either pleaded guilty in the United States to participating in agreements, concerted practices to fix the price of LCT, are under investigation in the United States, or are under investigation by the Commission in the EU for price fixing. So it's either under investigation in the US or under investigation in the EU. But either way, one can't say that an EU investigation is not good enough, but a US investigation is good enough. It must be the same for both. And one sees, if one goes in the judgment to the way the judge deals with this, and the validity of the pleading, one sees I'd simply give you the references, if I may, paragraphs 51 to 52 and 59 to 60. She has absolutely no hesitation in finding that the claim form and in 59 to 60, the particulars of claim were validly pleaded and not demurrable. So again, it is another example, we say, like Toshiba, of the generosity and the fact that these sorts of claims would not be struck.
It's not really generosity. It's simply that where you're dealing with concealed fraud, concealed bad practice, forgive me, I didn't mean fraud, concealed bad practice or unconscionable conduct, as Mr. Turner would say, the court is very reluctant to strike things out on the basis that that a regulator, which has access to much more information than any individual party, thinks there's something in it.
Well, my lord, quite. And we say...
And that's the problem for defendants,
yes.
But it's the problem for claimants in this case, perhaps.
My lord, as we say, I'm afraid it, and as observed in Arcadia, it must cut both ways. My lord, could I then...
I mean, the most important thing about this case is to provide certainty.
Yes. Yes, indeed. So that people know where they
I mean, it's always struck me that Section 32 has been construed in hideously complex ways, and that it's really quite simple.
Yes. My lord, could I take you back to the judgment then?
Yes.
It's in the bundle, core bundle, of course. And could I just take you through it with a little more care than my learned friend did?
Well, don't accuse him of not taking it. An awful lot to get through.
Forgive me.
You went through it.
Forgive me.
Very effectively. Yes.
Lord, yes. The starting point, if we could start with paragraph 24 of the judgment, which is on page 6.
Yeah.
And we'll see that the judge rightly says that what matters turn is the date on which Gemalto discovered, or could with reasonable diligence have discovered, the facts that were essential to establish a prima facie case against the defendant. And that's the key phrase, and you've seen how that is applied in the case law in Article 32, Section 32.
But it wasn't anything to do with could with reasonable diligence.
Yes,
In this case,
it's actual knowledge.
this is all about discovery.
Yeah. And then she identifies the four constituent elements of a claim of this nature. The agreement, having an appreciable anti-competitive object or effect, affects trade between member states, and causes loss. And you see in paragraph 26 noted, if it was established that Gemalto had sufficient knowledge of those identifying elements of the cartel, Gemalto accepted that it would also have sufficient knowledge that the cartel would affect trade between member states. So that's trade between member states follows from the cartel. And then it was also not disputed that loss and damage to Gemalto could be inferred from the fact that Gemalto had made purchases of the products subject to the cartel from suppliers within the groups of undertaking who had participated in the cartel. So again, loss and damage, one can strike out that element, that essential element of the cause of action. And if we then turn to what's then the real battleground, which is then whether Gemalto had sufficient knowledge of the identity of the undertakings who participated in the agreements, and whether they'd be involved in coordination of their market behaviour, or put simply, did they have enough to plead that there was a cartel in SECs in Europe involving Renesas, my client, or Infineon, Ms. Ford's client. And the judge goes through the material from the documents in paragraphs 30 to 39. And it includes the information on the contents of the Commission's press releases, the accompanying news reports, and the 2 RFIs that were sent to Gemalto. And Ms. Ford will take you through that material in due course in more detail. But except for the time period point, there's actually no dispute that the claim contained, if you like, that there was, if I could try to put it neutrally, that there was known to Gemalto some material to support the view that there had been anti-competitive collusion among smart card chip makers in Europe. And it's also accepted that the smart card chip makers concerned included Renesas and Infineon. And one sees that recorded a bit later in the judgment, paragraph 81, I could draw your attention to that, where the judge notes, Mr. Turner did not dispute that the claimant's press release announcing the suspected infringement set out the general nature of the agreement in sufficient detail to form the basis of a pleading, and also confirmed that the geographic scope of the agreement extended to the EEA. While the press release didn't itself identify the undertakings who had participated in the agreement, Philips, Infineon, Samsung and Renesas all confirmed that they had received the statement of objections. And this was reported in a Bloomberg article circulated within Gemalto. So when my learned friend says, well, the infringers didn't put their hands up and admit to the infringement, well, we did admit that we had received the statement of objections, and that was reported in the press. And so what it comes down to, really, is just, was the nature of the material of such a quality that it didn't suffice, that it could only give rise to suspicion and couldn't be sufficient to enable them to actually plead. And perhaps also
what Mr. Turner says is
Yes.
that it wasn't enough for them to have a reasonable belief that there had been a cartel, and therefore to warrant making it a worthwhile investigation and
Yes.
a worthwhile claim. And that's the case you've got to meet.
Yes, and
And to do that, you have to go to FII.
yes. And if one goes to, if I may then, this may not, perhaps I should go to FII in the morning.
Well, I agree when we're all fresh.
think-
But
yes.
is there anything else you want out of Mrs. Justice Bacon's judgment?
Well, there's,
Because you did say that Mr.
Yes.
Turner hadn't taken a stake.
Well, he
closer,
hadn't-
But actually, you've only looked at her recording the admissions in paragraph 81.
Yes. Well, my lord, we say I've already taken you to the critical part of her judgment where she analyses in our submission ways that really we can't improve on, the reasons why a statement of objections is a reasonable basis for a pleading. And we say that it's certainly a reasonable basis for a commencement of investigations.
I mean, she doesn't really tackle, does she, head on the point that Mr. Turner is making, which is that the statement of objections in itself is totally provisional.
Well, she says it's provisional, but it's also a preliminary. She does say that it is, rightly says that it represents the Commission's preliminary view. And as I've shown you, the best practice notice shows that it is indeed a provisional conclusion.
But any bit of it, as Mr. Turner says, and this is really a question of practice, any bit of it may be withdrawn. They may, for example, change the addressees.
Yeah.
So although it may be relatively rare that some kind of decision doesn't follow a statement of objections, the fact is that if you rely upon it to sue X or Y on the basis they're included in the statement of objections, you may turn out to be badly mistaken.
Well, you may. That doesn't change that has the court in FII at 200 page, paragraph 201 makes clear is neither here nor there. The fact that you may prove to be wrong is not the issue. The issue is whether you have a prima facie case. And certainly they had a prima facie case in the sense that they had sufficient to plead. If I could,
I mean, I suppose the point is,
Yeah.
it's slightly difficult to pin down. This is not a criticism, but what I think is said against you is if you simply put up a claim and say what's your answer to that, then at that stage it really is so preliminary that it's just as likely as not that there will be an answer, in which case it's not a claim at all. I mean, that's, I think, what's said against you. And so relying on it to found a reasonable belief, which Mr. Turner says on the cases is needed, is not appropriate.
well, there are many decisions of these types that may be from regulators that may be preliminary, but they would still, in our submission, start time running for the purposes of Section 32. Can I give an analogy? Let's suppose that one bought an item from an antique dealer, and and the antique dealer's terms and conditions stipulate that we will not be liable for we represent that this is a genuine antique, but we won't be liable if it's not, unless it's a case of fraud on our part. And then 2 years later, you get a visit from the police, and they say, we're investigating the antique dealer, and we suspect that he's selling fake antiques. We understand you've bought one from him, and we'd like to investigate it, please. And later on, a year goes by, 2 years go by, and then you learn that the antique dealer has been indicted for fraud by the police. And the question is, could you at that stage bring a claim against the antique dealer that would not be struck out by submission? Of course you could. You wouldn't have to wait for their conviction by the court. You could rely on the fact that there'd been a detailed and lengthy police investigation. And after an indictment had been issued, which is effectively what an SO is, effectively an indictment, you could then at that point bring your claim.
I mean, it's a nice example because of the facts, but in reality it's infinitely changeable. The facts of your example could change infinitely.
Indeed.
And the result may be different.
Let me try and cover it from another angle.
Well, it's 16 minutes past 4.
Yes.
Let's break now. I'm not taking back what I said this morning, but and if any of you need more time, you can have it. But I would have thought, we've got through quite a lot today, and I would have thought we might be able to finish by lunchtime, but don't anybody feel rushed. Okay, so we'll resume at 10:30 tomorrow.